All right, guys, welcome back to the podcast. As you know, if you follow my story for years now, you understand that it was not easy for me when I started. I was $65,000 in debt, fighting for pennies, working for minimum wage, trying to make my credit card minimums, just trying to find more credit to keep my business running. So debt was crushing me. But today, our guest runs the Crushing Debt podcast. He's an attorney out of Florida, helping real estate investors figure out their debt issues. We're going to go over a number of different things about how he helps with foreclosure sales, trust, all sorts of different topics that are going to help real estate investors. Let me introduce you to attorney Shawn Yesner from Yesner Law. How you doing, Shawn?
Good. Thank you for having me on the show. I appreciate it.
Yeah, so let's just quickly point out you have a podcast called the Crushing Debt Podcast. Guys, go over there, check it out. Make sure you leave a 5-star review because I know it's a great podcast. He's coming up on episode 100, so congratulations on that. But let's also go into kind of a little bit more about your background and how you transition to starting to work with real estate investors and helping them in certain situations.
Yeah, sure. So I've been an attorney now since 1998, coming up on year 20 next year. And I don't even believe it, but my first job out of law school was doing residential and commercial closings. So I got a ton of title experience working for an attorney down in Miami doing residential commercial closings. He also did immigration law, which I love the real estate. I did not enjoy the immigration. And so I grew up in Miami. I live in Tampa now, but I grew up in Miami, and I quickly realized that Miami really wasn't where I wanted to be in my career. It wasn't the same place I grew up. So in 2001, I found a job at what we now call a foreclosure mill. And so I was representing lenders, taking houses away, foreclosing on mortgages. And that gave me even broader experience into litigation, foreclosure, a lot more title work. I have a couple of reported appeals under my belt on foreclosure-related issues, litigation, bankruptcy, all of that kind of stuff. I got all of that experience working at the foreclosure mill. In 2004, right before the bubble, the owner of that firm said, "I'm shutting it down. I don't want to do this type of law anymore."
Yeah.
And, part of it was if you had just hung on for a couple more years, and then we would have had the bubble, and then we would have had more business than we knew what to do with. But, I roll with the punches. And so by that point, I'm 6 years out of law school, and I figure, what am I going to do so that my file doesn't come across my desk when I don't get paid? And I decided to switch sides. So I didn't want to move laterally. I hung my shingle, and off we went. And I started representing people who were in foreclosure, slowing the foreclosures down, doing loan modifications, doing short sales, doing bankruptcies, all for homeowners. Because of my foreclosure related experience, I also then started helping investors who said, "Hey, I've got this private money loan, and the person I loaned the money to on this house isn't paying me back." And so I would start doing foreclosures for them. And so I'm not representing, Chase and Freddie and all that. I'm representing Mr. Investor who has a loan with a borrower who's not paying. And that has done me well. That's then led me to the investor community, at least here in Tampa Bay. I do a lot of speaking for TBREA, the Tampa Bay Real Estate Investor Association out here. And, you can't represent investors without learning about subject to transactions and simultaneous closings and, LLCs and land trusts and other types of trusts. And so I learned all of that information as well. And so now in addition to the consumer side of the business where I help people who are just being overburdened by debt, I also help real estate investors with, like you and I were talking about, from start to finish, from soup to nuts, whatever you want to call it. So, how am I going to acquire this property? Am I going to become a wholesaler? Am I going to, take it subject to the existing mortgage? Am I going to buy it outright? How should I structure it? LLC versus land trust. What form of lease should I use? Am I going to pick it up on a lease option? Am I going to sell it on a lease option? All those different issues that real estate investors have to deal with. The tenants have trashed it. What do I do? How do I evict them? They're not paying me. Title issues. I just helped an investor with a title issue. We just wrapped it up a couple days ago. So, all the different issues that real estate investors face as they are on their journey of acquiring wealth. That's the message that I've been trying to get out there is that I'm here to help. I'm not here. Most attorneys have the reputation that we're here to blow up deals. I'm here to help you get the deal done. And I'm here to help you get it done so that you don't get sued by somebody in the process.
No, absolutely. Having someone like Shawn on your team is an incredible resource. There's so many aspects of this business that a new investor just doesn't understand, that they really need to understand a little bit more in detail before they start jumping in. It's not the wild, wild west out there like a lot of people think. Now, you mentioned something, we'll go into a number of different topics you touch on there, because I think a lot of people are going to be interested to hear what you have to say on each of them. But let's talk about foreclosures here real quick. So it's very important to have someone like you who was on one side, I guess the dark side of the force. So you moved over to the light side. Now you're a man of the people, I guess you could say.
Right.
And investors, like you brought up, jump in. They don't know what they're doing. They get in over their head with a hard money loan. They may need to stop the foreclosure process. Or on the flip side, when we're marketing with motivated sellers, this is a common situation in my business where we get individuals who come to sell the house to us. They procrastinate. They get into denial. They delay things. And all of a sudden, they're just a few days out from the foreclosure sale, but they got a decent amount of equity. And as an investor, if you don't know how to go in and stop that foreclosure, you can lose that deal and you'll let that family down. So let's kind of talk about some of the best ways that an investor can have you help them to come and stop the foreclosure, whether it's their foreclosure or a potential client or customer they're working with that's getting foreclosed on, that they want to stop that process.
Yeah, and I think one of the things you and I talked about before recording was that my license is only in Florida. So while I'm happy to talk to anybody, really the only legal advice I can give is if it concerns a property within the state of Florida. So the first thing that I would suggest is figure out what kind of state you're in. There's two different types of foreclosures. There's the statutory foreclosure where they just file paperwork, the case takes a couple of months and the property's gone, versus a state like Florida, which is a judicial foreclosure state, which means the foreclosure has to go through the judge and through the courtroom. And those types of states, Florida, New York, there's a whole bunch of them around. Those are the states where foreclosures take the longest, which give us the most opportunity to delay for purposes of getting to the end result, whether it be the investment or the short sale of the loan mod or whatever. So the first thing is figure out what kind of state you're in. Learn the laws of the state you're in. Are you in a judicial foreclosure state or a non-judicial, statutory state? Here in Florida, the other issue that we tend to face a lot, because we were one of the epicenters of the foreclosure crisis, and I think we're still just getting out of it even right now. The other thing to consider is a lot of the judges are getting upset because we're dealing with foreclosure cases that are from 2013, 2014, 2015. And the judges are saying, look, I don't care. Get this file off my desk. And we've gone in with where I've had a contract. And so we file a motion with the judge, please stop the foreclosure sale. Judge, here's the contract that shows the investor is going to pay off the loan in full, but you got to stop the foreclosure sale that's next week. And I've had judges say, sorry, no, your homeowner has had plenty of time to do that. The fact that they're waiting until the last minute is not the court's problem. I'm not stopping the sale. I've seen situations where even the bank is saying, judge, please stop the sale. So bank and homeowner are both saying, judge, stop the sale. And in some circumstances, the judges aren't doing it, I think, because they want to get the file off their desk. They want to move the case. They want to close the case. They want to make the clerk happy by getting another case resolved.
Now, it's one of my most frustrating things is when I get someone who's kind of pressed on time like that, and we're waiting to get that payoff letter from the lender, and they're just delaying. Is there something you can do as an attorney to step in the situation where you contact the attorneys for the lender? Because a lot of times that's what's slowing it down, is that they have the payoff amount, but they're waiting to get those attorney fees, and they're basically trying to calculate everything up. And a lot of times it feels as almost as if the lender's purposely trying to foreclose or stalling it so they can, if there's huge equity in it. But usually that's not the case. What would you do in this situation, or what's the best way to handle this?
Yeah, I don't know that the lenders really target and say this house has equity, we want to foreclose it, this house doesn't. I just think they're so overwhelmed. They don't know. They're just, the book says that I have to do X. And so as the frontline person you're talking to on the phone, that's what I'm going to do. But the first thing that I would do is let's file a motion with the judge. Florida also has, under its statutes, the lender has to respond to a request for a payoff. And so there may be something we can file in the court to argue for sanctions against the lender for failing to provide a payoff timely. Yep. Florida has the right to redeem. All states, I believe, have the right to redeem. In Florida, what that means is that I can pay off the entire amount of the judgment and I can save this house from foreclosure. And so I can go to the judge and argue the bank is interfering with my right, my statutory right to redeem because they're not giving me a payoff. So the first thing I would do is go to the judge, file motions in court. We've also got the CFPB, which despite all of its criticism, I happen to like the CFPB. It happens to be very consumer oriented, I think. And so we can file applications, complaints, whatever with the CFPB. We've also got potentially bankruptcy at our disposal. Bankruptcy will stop the foreclosure in its tracks and buy us some additional time, but we have to be careful about, I want to make sure that my clients are filing bankruptcy in good faith. I don't want them to file just to stop a foreclosure sale, but we do have bankruptcy as an option. And then again, just coming up with the money and tendering it to the lender, we've got that potentially as an option. But I think your best bets are to go to the judge.
Yep. So when it comes to filing bankruptcy, can we touch on the two different types, Chapter 7 and 13? And then, so from what I understand, if you file Chapter 13, it's a voluntary bankruptcy. They can stop the foreclosure, and then they can elect to withdraw from the bankruptcy and pull out of it. I've heard people doing, or is that?
Yeah, I mean, well, both chapters are voluntary.
Okay.
Both could be actually, I know Chapter 7 can be involuntary. I've been practicing bankruptcy now for something in the teen number of years, and I don't believe I've ever seen an involuntary where the creditors force the debtor into bankruptcy in a consumer situation. But I know both are voluntary, but you did hit on the biggest issue is that in a Chapter 13, you can voluntarily dismiss your Chapter 13 for any reason. You cannot dismiss a Chapter 7. And I think that's because of the purpose of the two chapters. So 13 is a repayment plan. Well, if you don't have the money to make the payments on the payment plan, you can dismiss the case. A 7 is a liquidation. So by dismissing a 7, you're potentially taking money away from the trustee and away from the creditors. And so the courts won't let us, the bankruptcy code won't let us voluntarily dismiss a Chapter 7. The other thing you can't do is convert. So you can't go from 7 to 13 and then say, well, 13 I can dismiss for any reason.
Yeah.
When you're dismissing a 13, you have to tell the court, we have not converted this case from another chapter under the bankruptcy code. But yeah, basically you are right. You can file a 13. That will automatically stop the sale. And then if we find later that the plan is unaffordable, that the plan doesn't do what we need it to do, that this bankruptcy ended up being a bad decision, then we can voluntarily dismiss it. I would never suggest filing a 13 with the intent to dismiss it because that's a bad faith filing. That's the definition of a bad faith filing, and everybody can get in trouble for that. At the same time, it happens. At the same time, I have voluntarily dismissed Chapter 13 cases when instructed by my clients. As a strategy, it's a little risky.
Yep. So let's look at the timing of the sale. A lot of times there's a lot of anxiety for these investors because they don't know if they're getting that payoff letter that is coming up to the time crunch. What is, can you stop it the day of the sale? Do you have to come in the day before? I get these questions all the time, right? Can you walk down to the courthouse and literally stop it right then, live time? Let's kind of go through that process because I think this is a question that a lot of investors want to know because I get this all the time, and they don't know what they don't know, right?
Right. Well, and here in Florida, we've moved to electronic filing, and we've also moved to most states do auctions online. So I remember the days. I've actually been to foreclosure sales that are literally at the courthouse on the courthouse steps and seen bidders and seen investors bidding over it. But I think almost every county in Florida has now gone to an electronic auction. So theoretically, yes, it would be possible to show up on the day of the sale and say, hey, we've resolved it, we've paid it off, we've reinstated it, whatever, please stop the sale. And it can happen. It's risky because most of the sales are at 10 o'clock a.m. Eastern time. And while you're at the courthouse saying, please stop the sale, the auction process may be going on in the background automatically.
Yep.
And so when I'm doing something like this, can it be done? Yes. Have I done it before? Yes. But I always feel more comfortable at least the day before. Let's get in there and try to stop the sale. If we wait till the day of, it might be too late. Maybe we can unwind it after the fact, but then that opens up a whole other can of worms.
Yeah. So that's what I try to get people to do as well. Don't even take it to the last minute. Just get it done the day before.
Right.
So let's assume that they paid it off at the bank wire at 10:58. You submitted everything, or 9:58 before 10 o'clock. But they're probably not going to know this. They're already going to auction off. What would happen if the auction process went through, yet they did pay it off and everything was submitted a minute before? Has this ever come up? Have you run into this?
Yeah. Yeah, it has. And so a couple of different things. If the bank ends up buying back the property at the foreclosure sale, then no harm, no foul. The bank would just file a motion to say, please unwind the foreclosure sale, and the payoff goes through. I think where we get into trouble is where a third party bidder comes in, an investor. So if the house has a ton of equity and an investor comes in and buys the property, that's going to be much harder to be unwound because it's a third party. There was actually a Florida statute. I think it's maybe 3 years old by now, 4 years old by now, something in that range. And what the statute says is that if the bank improperly sells the property at the foreclosure sale, the homeowner's damages are limited to the amount of the mortgage. So basically, you get your money back. You can sue the bank for damages, but you cannot, the statute specifically says, you cannot sue to get the house back. You can only sue to get money from the bank. And so that was sort of the legislature's way of communicating to the investor community, get your act together before everything happens, because if it runs too long, you're only going to be eligible for money damages. You're not going to be able to get the house back.
Okay. So that's a lot of really good information. Let's go and transition here. We're talking about foreclosures. And one of the strategies that we teach our students is how to market to low equity properties, people on the pre-foreclosure list, because this is one of the best opportunities for a new investor who doesn't have a lot of money, who hasn't been able to raise money, to build their portfolio through buying houses subject to. Because if they don't have equity in the house and they've got past the point of where they can do a traditional retail sale, because it takes 30 days, for most houses to close, they can't go that route. There's no equity for a wholesaler or a rehabber to come in. So someone has to come by at sub two. And this is a really hot topic in the investing world. Everybody loves to talk about just get the deed, get a free house, but there's a little more to it, right? This is a very risky transaction. It has to be done correctly to be safe for the homeowner and for the investor. Let's go into the subject to process, because I know you help a lot of people with this, and kind of what you do to help them in this situation as a new investor.
Well, and again, in Florida, we have a statute that describes what an investor needs to do if they're going to help someone in foreclosure. And there's certain disclosures that they need to make. There's certain disclosures in writing that they need to make. And so in my mind, the biggest risk of the subject to, and what we saw here in Florida when the bubble popped, was a lot of investors were taking properties subject to. And so what the homeowner doesn't realize is they're still on the hook for the loan payments. And there's a lot of good investors out there that put a renter in there and they make their payments every month. And I'm taking this house subject to your loan, and so I'm going to pay your loan until the very end. There's another subset of investors that said, I can't afford to rent the house out anymore. I'm done. And so left now borrowers holding the bag. So now banks were filing foreclosure cases, including the borrowers, sometimes 6, 7, 8 years after the subject to transaction had occurred. And so here I am, a homeowner, and I get sued in a foreclosure case. And remember, if I'm the homeowner and the investor took title subject to my loan, that means I'm still on the hook from a liability perspective, not the investor. And so now banks coming after me for money 5, 6, 7, 8 years after this transaction occurred. And so that was getting a lot of investors in a lot of hot water. And that was pretty much what led to Florida enacting those foreclosure rescue laws that we have on the books now of the different disclosures you have to make. Now, we do have the other side of it. And I remember very early in my career helping investors, I had an attorney call me. It was my biggest investor client. He was a big fan of subject to. And he was one of those guys that always did it right. He always made the mortgage payments. He always did what he needed to do. And I remember having another attorney call me and say, tell me why I shouldn't sue the stuff out of your client. And I said, well, let's take a look. First, my client gave your client $5,000. Second, my client caught up your client's loan and has paid every mortgage payment. My client put a new roof on it. My client put a new AC unit in it. My client let your client stay, which I don't recommend, but let your client stay, and your client's rent payments are less than their mortgage payments. And he put in writing how your client can reacquire the property once they reestablish their credit, which my client paid for after X number of years. Tell me again exactly how my client took advantage of your client. And the attorney said, thanks, I'll talk to you later. And I never heard from him again. So, if you're doing it right, you're doing it right. It's the ones that basically skim the equity and walk away. Those are the bad ones. Those are the ones we need to get out of the industry.
I mean, it's kind of like giving a loaded gun to like a second grader sometimes when you teach people to do this and they don't know what they're doing. They don't know the risks involved. And you touched on something very important. Guys, do not ever, if you take a house over because they're not making the payments, let them rent the property. I mean, clearly it should be common sense, right? Because if they're not making the payments before, what makes you think they're going to make them now, right? So
exactly.
What are the catching points that you see new investors that come to you, and I'm sure they bring you contracts all the time. You're like, oh my gosh, what were they thinking? Like, they basically just put it together on a napkin or whatever. They don't understand how to put this type of transaction together. What are some of the main faults that you see for new investors, or where is their confusion when they're doing this type of transaction that you see they mess up on regularly?
Yeah. And I have probably a split of clients. I have some investor clients that have their own custom form that they like using. And I don't mind that, their own custom contract that they're going to acquire the property from the homeowner. And I don't mind that. If you've got a custom form, at least let me review it. I think one of the biggest mistakes I see with custom forms is it's somebody who wants to buy a Florida property, but they've got a custom form that some guru in Minnesota gave them. One might not fit in Florida. Florida does have two forms of contract that have been approved by the realtor organizations and the Florida bar. And those are the two that I like, and because they lay out everything. And so some investors don't like using them because they're 10 pages long, which is a totally other issue. But some investors like using the one-page simple contracts, which I'm okay with. But if you're going to do something like that, run it by me first. Let me take a look at it. Let me make sure that it doesn't say something specific to Minnesota law that won't apply in Florida, or maybe it's missing something. I can't think of anything right off the top of my head, but the biggest mistake I see is either using the forms from the form banks, so going to Office Depot or Office Max or whatever office supply store and buying a form off the shelf, or like I said, using a form in a state that doesn't apply.
Yeah, so a lot of investors like the subject to strategy because they think it minimizes their risk, because they basically have the debt left in the original borrower's name, and they think that that's somehow good to basically use that strategy for that reason. But really, I think that's the wrong mindset to have that, because you're assuming that something could go wrong and that you're basically going to stick it on the other borrower. Are you seeing a lot of different people coming in doing loan assumptions, or are they just trying to take houses subject to, or have you even seen people doing this?
I don't see as many subject to transactions right now, only because we're still, like I said, in Florida, we're still in the middle of this recovery period. So I don't see a lot. I do see them starting to gain in popularity, but I don't see them very much. And we're still not quite getting that many houses with a ton of equity. I mean, they exist out there, but typically it's paper equity. It's a couple $1,000s of equity, or it's upside down, or break even, or whatever. So I did do a lot of subject twos when the house was worth $100,000 in the morning and it was worth $110,000 at night. That's when I was seeing a ton of subject to transactions. I am still seeing them. I'm just not seeing them as often. And I assume as property values continue to rise, I'll see them more often.
Yep. So your main goal is to help investors, especially when they get in debt situations. Let's kind of touch on, a couple other topics: credit restoration, land trust. These are pretty common topics that new investors or even experienced investors need help with. What is it that your main focus is when you're working with investors when they come to you and they're in debt or they're trying to get out of a situation? Are you helping them with credit restoration, or do you work with third-party companies that you can help them with, or how does that process work when they come to you?
Yeah, I typically do not do the credit restoration as a function of what the law firm does. I do have a lot of other credit repair companies all over the country that I partner with, and I've always been a big proponent of, I stay in my lane, you stay in your lane. I don't want to be what's the saying, a jack of all trades and a master of none.
Yeah.
So now I do understand credit reporting. I do understand the factors that make up a credit score. I do understand how to look at a credit report and see if there's been a violation of the Fair Credit Reporting Act. But typically what I'll do on the credit repair piece is I'll send it over to a credit repair company. The other thing that I do, if I do have an investor that comes to me with a ton of debt, well, let's figure it out. Is it real estate related? Can we maybe unload some of these houses to get more money to then fund maybe paying off other creditors? A lot of times we can get creditors to take pennies on the dollar, some percentage on the dollar, either as a lump sum or over time to go away. And so I do negotiate with creditors for investors, for other people. I do negotiate with creditors to go away. I got one the other day that offered me 40 cents on the dollar from what the client owed.
Wow.
So I got one. I used consumer creditor harassment laws, the Fair Debt Collection Practices Act, and then Florida has the Florida Consumer Collection Practices Act. And I got $21,000 to go away. Wow. Because they were being too aggressive in the way they were trying to collect it. So I've done a bunch of that stuff as well. And then just generally, part of it too is looking at the investor's portfolio to see what do you got. If they have a lot of properties in their own name, let's move those properties into LLCs or land trusts to avoid the liability. Those types of things to help clean up credit.
Yeah, so a lot of investors get themselves in trouble when they start out and they go to these supposed credit line companies, right? And they say get 50 to 250K unsecured lines of credit, but what they're really getting is business credit cards, and they tell them they're going to get 6 to 18 months, 50 to 250K, 9% to 24%. So they get all caught up on the front end number because they think they're going to get 6-month cards with, huge 0% interest periods. And then they get, 50,000, short interest or high interest and short, rates. They run up debt real quick. So when you're talking about helping them get out of the situation, are they going to a debt consolidation company, or how would that process work? Because I know a lot of investors get caught in this situation. They come to our company, they need help, because we do training for real estate investors, and this is very common. I see a lot of people 50 grand in debt. It happened to me when I started my business. How would someone go about the process of working to kind of relieve some of that stress and get pennies on the dollar off that debt?
Yeah, the other thing to realize is that a lot of those 0% credit cards, if you don't pay before the term is up, so we'll give you 0% for 12 months.
Yeah.
Well, if you don't pay off the card in 12 months, at month 13, that interest rate kicks in, but it kicks in for everything. And so now you're paying even on some of the 12 months that you had been paying while it was at 0%. And a lot of people don't realize that. I'm not a fan of credit consolidation. So I'm not a fan of, we're going to take all your debt, we're going to wrap it into one payment, and we're going to pay that every month. I mean, in essence, that's what a bankruptcy is.
Yeah.
So if I had a client who was worried about consolidation of debt, bankruptcy might be as good or better of an option. The other thing that I don't like about credit consolidation is a lot of these companies got in hot water. And again, Florida and federal put in rules to protect homeowners or to protect borrowers against this, where the consolidation company was saying, well, listen, pay me. We anticipate that we can get all your debt settled for a low payment of $300 a month. So pay us $300 a month. Well, what they were doing is they were taking their fees right off the top. And then once they got a sufficient amount saved up, so we saved up $3,000, we saved up 10 months worth of payments. Now we're going to call your first creditor and say, hey, we got $3,000, take it or leave it. The way that I do that is I allow the borrower to collect that money. And then when the borrower tells me, hey, I've got X amount of dollars saved up, now I call the creditor and I say, hey, we've got X amount of dollars saved up. I've always been one of the things I say a lot in my line is debt negotiation is not poker. I'm not really bluffing. Maybe if there's any creditors listening, I never bluff. If there's no creditors listening, maybe sometimes I do bluff. But if I've got the hand, if my client has no assets that can be collected against, if my client has no wages that can be garnished, if my client has none of that stuff. I just talked to a guy today. He emailed me. He was $50,000 in debt, but his only source of income is Social Security disability. And I said, well, yeah, bankruptcy is going to help you because it'll eliminate all that stuff. But if you've got a thick enough skin, Social Security disability cannot be garnished or taken by any creditor. So you can literally let the creditor sue you all they want. They're not going to get a penny.
Yeah.
Because all of your income is exempt.
So, guys, it's very important to understand what we're talking about here. It's very risky. There's a lot of these companies out there, and they mislead you, and they make you think you're getting a credit line, but what you're really getting is a culmination of a bunch of business credit cards. And like you said, they basically can, if you read the fine print, they have full control over what they do. I had one card that I had a real low interest rate. It was like 11%. I say that's low, but for a card, I made payments on it for 2 years, and I ran up a decent sized balance on it. And I paid it off in full, as I do all my cards. I try to when I can. And then there's interest that carried over. It was like, I don't even know, it was like $80 of interest that I didn't pay. And I forgot that I didn't go back and look. And I didn't pay my minimum payment, which was like a few dollars on an $80 interest overcharge. And they jumped me literally to like 29.5%, something ridiculous. It was almost 30% interest. And I contacted them and I said, I've made all these payments. I made you all this money for like 2 years straight. It was a very long time. And they told me it was going to be 6 months before they reduced the rate down. And I was like, I just won't use that card. But they didn't even care. And so they have full control over that situation, guys. And I know when you talk to them, these companies, make sure you get one line because they're going to tell you they can pull all the cash off. They're going to give you all these shady ways, in my opinion, to pull the cash off. But it's very, very risky. And what you're really going to get is like a baseball album full of different cards that you're going to have to use. And it makes it tough because you have small balances, $3,000, $5,000. So it's very important to understand that. So let's talk about, before we move on, let's go back and talk about the bankruptcy process. You brought that up just a second ago, where it may be a better option. What is, people here going through a foreclosure or going through bankruptcy is like Armageddon. It's like dropping the atomic bomb on them. What is the actual devastation or damage that someone's going to deal with later? How long is their credit going to be messed up? How long before they can buy another house? Is their career over? Is it the end of the world? Let's talk about the negative consequences and how fast someone can recover and bounce back from this.
Yeah, interesting. I've been trying to do a lot of blogging and writing and podcasting and talking about this, is that the impact of a bankruptcy is fairly negligible. Most people come in and they worry about their credit. Well, if you're behind on all these cards that you say you're behind, your credit's already taken a beating. Yeah. It's not going to get much worse if we file bankruptcy. Typically, the bankruptcy will appear on credit for 7 years. Its impact will only be 2 or 3, depending on what you're trying to do. So if you're trying to buy a house using VA financing, you're probably looking at 3 years. Or FHA financing, you're probably looking at about 3 years. As of, typical attorney disclaimer, as of the recording of this episode, typically if you're going to do conventional financing, you're looking at 2 years. If you can figure out a way to do seller financing, owner financing, subject to financing, hard money financing, you may be able to do that depending on who you're borrowing from the day after the discharge. It just all depends on who the lender is. The biggest negative that I see of a bankruptcy is really the perception of what a bankruptcy is. Yeah. It will eliminate debt. It'll consolidate debt. It'll pay off debt for pennies on the dollar. I've used bankruptcies in situations where one of my best success stories, two of my best success stories with bankruptcies. One was a couple. The husband is a realtor. The wife owns a bookkeeping company. They were just in over their head. The real estate wasn't selling. People weren't hiring her to do bookkeeping. And so we filed a Chapter 7. Within 2 years, they had moved down to the water and bought financed a $300,000 house on a golf course within 2 years. That was probably 06, 07, 08, somewhere in that time frame. But they were able to, 2 years after a bankruptcy, finance a $300,000 house on the golf course by the water. I had another client, a husband and wife get divorced. Husband keeps the house. But one thing most people don't realize is the divorce does not eliminate the debt. And so both parties were still liable to the bank, but the husband kept the house. The husband died years later, unrelated to the marriage to the wife. Husband dies years later. The bank files a foreclosure, and we're worried about the wife either getting pursued for the deficiency or the 1099, the forgiveness of debt, the phantom income tax liability. Well, the problem was the wife had now become engaged to somebody else who was making 6 figures. So bankruptcy is based on household income. Even though the wife wasn't working, the fact that the fiance now made six figures, that household was a six-figure household. She would not have qualified for a liquidation bankruptcy. So we filed a Chapter 13 bankruptcy for her. The fact that the mortgage was in foreclosure, the bank did not file a claim in the bankruptcy case. So the bank gets nothing. We had one credit card company file a claim for $400. So we called the bankruptcy trustee. We said, please give us a payoff on this bankruptcy case. The trustee said $400 plus whatever other expenses we've incurred here. The fiance paid it off. She got her discharge. The bank couldn't come after her for 1099 liability, none of that kind of stuff. So we used the Chapter 13 basically just to get her out of this potential tax liability or bank liability. And it worked out fantastic.
I'm glad you kind of went over that, because I think a lot of people are feeling a lot better right now, because a lot of them really, really assume that their life and their business is over, that if they go through something like this, they're never going to bounce back. Let's talk about something else when it comes to bankruptcy. So my business, we do own rental properties, but a lot of what I do is owner financing. And let me see if I get this story right. So one of my mentors, he had a situation where he was owner financing a property. They stopped making the payments. He was going to basically foreclose on them. And right before the husband filed bankruptcy, and it tied the property up for a number of months. And as soon as they got it out, they started the foreclosure process again. And then, like, right before it, somehow the wife independently filed bankruptcy again and stopped it again. And they somehow, played the system. There's actually literally websites out there called like Beat the Landlord or something, where people actually go out there and figure out how to take advantage of these spots. Is there anything you can do? Because you may have a huge underlying payment on that property, you have liabilities to it, and if they're tying it up, is there any way to penetrate that or kind of get around that if someone does that to you?
Yeah, maybe. If it's a landlord-tenant situation, the way the bankruptcy code reads, and again, one of the interesting things about bankruptcy is it's federal law, but every different area has their own local rules, state exemptions. So a bankruptcy in Florida looks different than a bankruptcy in Georgia. A bankruptcy in Tampa looks slightly different than a bankruptcy in Orlando. So with that sort of overlay, the bankruptcy code does say that if you are a landlord and you get all the way to the writ of possession, where you're entitled to get that house back, and the homeowner files bankruptcy, or the tenant rather files bankruptcy, there is no bankruptcy stay. You could continue on with the eviction. Now, you want to double check your local rules to see, do I have to file a motion to have the court confirm that? How do I do that? But in general, the bankruptcy code says if you're a landlord, if you're not a landlord, if you're an investor and you run into the situation where the husband files and the wife files and the husband files, the bankruptcy code was amended in 2005. That's the amendment that everybody said was going to make it harder to file bankruptcy, which really didn't happen, especially during the crash. We had a record number of bankruptcies. Yep. But that 2005 amendment, what that said was that you got to look, there's a lot of different issues in there. You got to look, is it a 7 versus a 13? Is it a liquidation versus a payment plan? If the stay was lifted, if the bankruptcy stay was removed in one case, there's a possibility that stay removal carries over into the other case. There are provisions in the bankruptcy code that say it's the property that loses the bankruptcy stay, not necessarily the homeowner. So if the husband files and then the wife files and then the husband files, there may be no bankruptcy stay because they keep bouncing back and forth between that. I think the best advice probably is going to be to contact an attorney local to where you are, just to make sure that you understand the local rules and what can and can't be done. Probably that first case is going to frustrate the sale. Probably that second case is going to frustrate the sale. When you get beyond 2, then it gets a little bit more hairy for the people filing bankruptcy. It gets a little bit easier to take control of the property. The other interesting thing that we have going on here in Florida, the bankruptcy trustees have now realized that there is value in short sales. And so I had this happen to a realtor client of mine the other day where the homeowner, they had a short sale ready to go. They had the buyer, they had approval, they had everything. Some attorney, not me, got hold of the homeowner and convinced him to file bankruptcy, a liquidation Chapter 7 bankruptcy filing. When they did that, they happened to pull, we have, I think, 10 or 11 Chapter 7 trustees here in Tampa. They happened to pull one of the trustees that is very experienced doing short sales. And so the trustee said, well, fantastic. The instant you file bankruptcy, the fact that you're giving up your house now belongs to the bankruptcy estate. And I've got attorneys and realtors and short sale negotiators. And so what they did was this particular trustee then sent a new short sale application as the bankruptcy trustee to the lender requesting a $15,000 carve out for the bankruptcy estate. And the lender caved because the lenders are so scared of bankruptcy and bankruptcy trustees.
Yep.
That they were like, whatever, our debt's discharged anyway. You got the buyer. We'll carve out 15 grand. And so this bankruptcy trustee was able to create $15,000 to pay herself and to pay the unsecured creditors. And I don't say that to be critical of it. I don't say that to criticize the trustee. That's just the way it's developed here in Tampa and in most of Florida, I think.
Yeah. So I know you work with land trusts. What if they had owner financed the property and taken title on a land trust originally, or are they able to use this to avoid dealing with the bankruptcy, from what I understand?
Maybe. The issue with a land trust, a lot of people think land trust is an asset protection tool. And I think it does protect assets somewhat, but here in Florida, a land trust is really an anonymity tool. Walt Disney bought Disney World, bought all the property around Walt Disney World using land trusts because he was able to hide himself and hide who was buying what. And so the issue is, and a lot of people say the same thing in connection with a business, an LLC. I own an LLC and I want to file bankruptcy. What we have to remember is that the value of the beneficial interest, because remember, in terms of a land trust, the beneficial interest is now personal property. It's not real estate. So that personal property has some value to it. The membership interest in an LLC has some value to it. So the trustee is not going to come in and take over the land trust. The trustee is not going to come in and take over the LLC, take over the business. What they're going to say is the value of that beneficial interest is X amount of dollars. That value needs to be paid to the creditors if it's not exempt. The value of that LLC. I had a hairdresser once. She bought a salon and she was doing really great because trustees and judges here in Tampa won't let us say, a lot of people come in and say, well, if I stop practicing law, the value of Yesner law is zero because I'm the only attorney here. So if I stop practicing, my firm's with zero. And a lot of people take that approach, but the judges and trustees have said, no, it's worth something. And so this hairdresser was doing a really great job with the trustee. I rent out all my chairs. I don't own any of my brushes, doing a fantastic job of showing her salon was worth $0. And then the trustee said, how much did you buy it for? And if someone offered to buy it from you, how much would you want to sell it? My client said 20 grand. Trustee said, oh, then your LLC is now worth 20 grand. I want 20 grand to pay to the unsecured creditors if you want to keep your LLC. And so it's not that the trustee came in and took over the salon. It's not like the trustee is going to come in and take over the real estate investments, but they're going to say, what is the value of that stuff that we can now liquidate to pay to the unsecured creditors?
Yep. So there's confusion. I get this question a lot. People want to know, are land trust judgment proof? Can they go attach a judgment and say contractor's lien, or does this protect people, investors from this if they buy their properties on land trust? Is this something that you do a lot or know about? I don't know how much. I know you helped create the land trust, but is this something that investors can use to their advantage?
Yeah, and that is true. So if I have property in a land trust and I get into a car accident and somebody sues me for causing the car accident, yeah, my interest in the land trust is not only is it anonymous because of the nature of the land trust, but it's also it is a little bit protected. One way that investors can even strengthen that is they make the beneficiary of the land trust an LLC. And so now they've got the anonymity of the land trust paired with the asset protection of the LLC being the beneficiary. And yeah, it's going to be really hard to break through that structure to say, okay, Shawn caused a car accident. We're going to sue him for $1 million. We're going to go after his land trust. Well, good luck finding the land trust. Good luck finding if I wasn't driving for purposes of that land trust, then the LLC is going to protect me. Plus, I also tell all my investors, buy insurance. Insurance is going to help. I mean, that's what insurance is for.
Yeah.
So the insurance will take care of you there. But yeah, the land trust and the LLC can help from that perspective of keeping people insulated. I'll give you another example. I had a potential client come to me that I ended up turning away. It was a case in Florida, and I think everywhere else, you have to disclose issues with the property. And so it was a situation where the seller didn't disclose. There were a lot of repairs that need to be made that were hidden, that couldn't be found. And the seller didn't disclose it. And so that's a textbook case, at least here under Florida law, where we could sue the seller for those damages. And so I'm meeting with the client, I'm going through all their documents, and I see that the seller of the property is a land trust. Now, keep in mind, I've set up hundreds of land trusts. I know two of the biggest names here in Florida that are land trust trustees as their careers. I looked at this thing that said it was a land trust, and I looked at the buyer, and I said, sorry, I don't know if I can help you because, number one, I don't know that we're ever going to find a person at the end of this thing to be able to latch onto, to sue, to get assets from. And number two, even if we do, could be years down the road, and they could be paying. Now, in this particular situation, I think it was like $4 or $5 grand worth of repairs. Well, from my perspective, by the end of this thing, by the time we actually find somebody, it could be 3 to 4 times what it was going to cost them to make the repairs.
Yep.
And so my legal advice was, or my practical advice was, go ahead and make the repairs, chalk it up to being a homeowner, and move on. Because let's say I'm able to recover the $5,000. I can't tell you that I can recover the $5,000 a year from now, 2 years from now, 5 years from now.
Yeah.
And the longer we take to recover it, the more it's going to cost them in attorney's fees. And while we may get those attorney's fees back as part of the damages, as part of the judgment, who knows how long it's going to take us to find that.
Yeah.
Now, if this were $50,000 or $100,000 in damages, my opinion might have been different. But for $5 grand to chase a land trust, it wasn't worth it to me. And I know a ton about land trusts. And so from that perspective, even it showed me that they're useful in terms of a protection tool.
So because you've done so many, I'm curious, Shawn, to hear your opinion on what I'm about to ask you. So land trusts are a point of high anxiety for investors. It's, land trusts, IRAs, things like this. When they start their education process, they know they need to learn these types of things, but this comes down the road after they start making money flipping houses, wholesaling houses. Most people don't realize how easy the process is to set up a land trust. How do you recommend an investor to go through the process of taking title in a land trust? Do you want them to close on it first and then transfer title into a land trust, or do you want them to create the trust before they even take title? And I think a lot of investors don't realize how fast they can actually create that trust. I know fellow investor partners of mine that actually have, using Podio, automate the trust creation literally 1 minute using automated system before the offer goes in. So they're actually creating a trust lifetime documented. Like what is your best opinion on how to do this? And then kind of let's talk about the cost of something to do, or the cost to do something like this.
Yeah, it's going to depend on how they're buying the property. So if they're going to use traditional lending, then they have to buy it. Most traditional lenders are going to say you have to buy it in your name individually. And so then after the closing, we'll move it into a land trust. If they're going to be buying it using some type of owner financing, some type of creative financing, if they're going to be buying it cash, then yeah, we can set up the land trust prior to closing and then close in the name of the land trust. And it really takes 2 documents. It's the land trust agreement, which is anonymous, which is an internal document. So only the investor has access to the land trust agreement. And then it's the deed that moves the property into the land trust. Those are really the only 2 documents you need. There are some other documents there, powers of direction, powers of other different things in there, but basically all you really need is the land trust agreement and the deed. Typically, the way that I charge, a couple of $100 to create each of those documents. I typically would consult with the investor first and say, who is going to be the trustee? Who is going to be the beneficiary? I have made the business decision not to be a land trust trustee, only because it's like I said before, it's outside of my wheelhouse. It's outside of I just don't want to deal with being a trustee. So I work with two other companies that are land trust trustees, and they charge a couple of $100 a year for all the maintenance. They charge, here and there if there needs to be any changes. By and large, I don't think you would have to pay more than, I don't know, $500, $750, maybe max of $1,000 to set up a land trust, and it depends on the circumstances. So the first thing we need to look at is how are they acquiring the property, and then once we know that, we can put the other pieces in place.
Yeah. So when it comes to taking the property down, and before y'all make your offer, like what he brought up, is it's important to understand that these banks getting a conventional loan or FHA loan, they're not just going to loan on land trust, right? So when you transfer, so you take title in your personal name and you transfer it over, have you run into any issues with the due on sale clause? Have they called these loans due, or because it's, like you said, it's not being filed, they may not even know, or what's let's pull back the curtain and kind of go through this process, because this is very confusing for investors. And when they're confused and they don't understand something, it creates paralysis analysis.
Right.
They don't take action because they're scared to make a mistake.
Right. From a title perspective, I would say wait until the deed gets recorded, then record the deed into the land trust. Wait till the deed into the individual gets recorded, then record the deed into the land trust. You don't want to run into a situation where, as the attorney that prepares the land trust, maybe I get a little overzealous and I record the deed, and then the title company hasn't recorded the deed into the individual yet, and so we've got them out of order. So that would be step one. But beyond that, no. 20 years of practice dealing with 17 of that dealing with mortgages, I have never in my career seen a bank sued based on a violation of the due on sale clause, ever.
Yep.
I have, the only time I've seen it is when payments fall behind and then the lender does their title search. They see that it was moved without authorization of the bank, and so they add a separate count and they say, well, you're in default because you didn't make payments. You're also in default because you moved the property in violation of the due on sale clause. I have never seen a lawsuit solely for violation of the due on sale clause. One time I had a client whose loan fell behind, and we were trying to reinstate the loan. We had the money to reinstate the loan. The bank would not allow the reinstatement because of the due on sale violation. But even then, payments fell behind. That's how the bank figured it out. So technically, it is a breach of the due on sale clause, but as a practical matter, as long as the payments stay current, I've never seen it. Now, there also is a law that says, a federal law that says, if the beneficiary of the trust is the owner of the property, there is no due on sale violation. But in the investor world, we know that a lot of times the beneficiary of the land trust may start out being the homeowner, but at some point that beneficial interest is going to transfer to the investor. And so even in that type of a situation, there would be a technical breach of the due on sale clause. But as long as the investor continues to make payments, the bank's never going to find out.
Exactly. I think there's a lot of unnecessary fear mongering when it comes to due on sale clause in this business. A lot of investors are just so scared of this. And yes, you can go to the beach and get bit by a shark too, but Amy Sayer was on our podcast. She runs a large loan servicing company here in Texas called August REI. She said in 15 years, she's only had like 4 cases. And the worst thing that happened was they had to sell the house and basically capture their profit on the front end. So I wouldn't be too worried about that. Plus, like you said, guys, as long as you're making the payments, that's really all they care about. And then unless interest rates jump up to 10 or 12%, that's the only reason I would ever worry, is if they want to call these loans due, because they want to bring that money in and loan it back out at a higher rate. Is there anything over the land trust process that we didn't touch on that you think is super important that I may be missing for new investors?
No, I think we covered it. I think we pretty much covered it in detail. The only other thing that I hear is that the violation of the due on sale clause is criminal, and that's totally false. There's nothing criminal about the due on sale. You're basically in breach of contract. And so, like you said, the bank's going to call the loan due. But in terms of land trusts, the only other issue that we hadn't covered, some investors say to me, well, how many? So I've got 10 properties. How many land trusts? my thought is you do one land trust per property. And at least here in Florida, the way that we name the land trust is with the property address. So, trustee company as trustee of the 123 Main Street Land Trust, for example. And so I typically advise one land trust per property. Now, if you're going to go the LLC route, then I say however many properties are at your comfort level. So if you're, 5 properties per LLC, when you get to property number 6, you start your second LLC. And the reason I say that is the land trust, depending on what trustee you use, you may have a very small annual maintenance fee for that land trust. But when you talk about LLCs, now you've got annual dues to the whatever Secretary of State of whatever state. And so you have 10 properties in 10 LLCs. That's thousands of dollars a year just to maintain the LLCs. If you have a risk tolerance of 5, now you've dropped it to 2 LLCs for 10 properties. You've lowered your administrative costs. And again, you overlay insurance policies on top of all of that to protect yourself too.
Yeah. So guys, if for some reason they threaten to call the loan due on you, simply just explain to them that you had a check that you're going to send in for next month's payment, and you have a good history, and just explain to them what went on. This has happened to a number of people I know, and they basically were like, okay, we'd rather just keep on taking the payments, right? So yeah. I know a lot of y'all are jealous and wish you were in Florida. Unfortunately, you're not. But if you are in Florida, you can reach out to Shawn. We'll give his contact information here in just a second. But I want to touch on your podcast here. But before we do, what would be the best way, assuming, obviously getting referrals, for an investor in a different state to go find a high-level attorney that can help them with these issues that you could in Florida? Because unfortunately, most of us are in different states. They're going to listen to us or even in Canada. How, from the investor side, what's the best way to find a quality attorney aside from just a referral, like just going on the internet? How is there a rating service, or is there a way to check it, to see, is there any way to figure this out?
Yeah, there are a couple different websites that I belong to. One is called Avvo, AVVO. It's avvo.com, and it's a website where you can ask a question. And then as the attorney, I have different subscriptions. So I subscribe to Bankruptcy and Chapter 13 and Chapter 7. And when I see a question pop up, I can answer it. And then if you like my answer, you and I can connect that way. So that might be one way you can do it. On the consumer end, I belong to a website or an organization called NACBA, NACBA. It's the National Association of Consumer Bankruptcy Attorneys. And there's an attorney finder button on that website. There's also the American Bankruptcy Institute, ABI. There's a bankruptcy finder on that website. The other thing is, I don't mind if they contact me. I do have connections in other states with counterparts. Not every state, but some states. I'm a Florida boy. I was born in Florida. I was raised in Florida. But the only 3 years I was not living in Florida, I was in Birmingham, Alabama for law school. So I do have a lot of contacts in Alabama. I have a lot of contacts in Georgia, in the Carolinas. So I may not know somebody, but I may. I'm on a couple different Facebook forums as well, where I can shoot out an email that says, hey, looking for an attorney in such and such area. The other thing I would say is I offer a free consultation. And I'm not going to speak for every attorney out there, but I assume most of my counterparts would offer a free consultation. If they do, sit down and talk to them. What is their experience? How many properties? I mean, I am not right now, because I've got the law firm, I've got a title company, I've got the podcast, I do some referral-based marketing training, and so I've got all that going on. So when I saw the bubble coming, I got rid of all the investor properties that I owned, but I have been a real estate investor, so I have sat in your shoes, and I do know what you're going through. So I would ask the attorney, what kind of foreclosure experience do they have? What kind of investor experience do they have? Do they understand land trusts? I've taken the land trust trustees that I refer to, I paid and took their classes. So I've sat in those classes as well. I've spoken to TBREA, the Tampa Bay Real Estate Investor Club. I've been doing that since 06, 07. I've been speaking to the Tampa Bay Real Estate Club. I speak to other groups too. So those are all the things. Yep. If I were going to look for an attorney, those are all the types of questions that I would ask. And again, trust your gut. If you got a good feeling about the attorney, go for it. We're all governed by our various state bars. So if I were to do something bad for an investor client, not only could they sue me for malpractice, but they can also go to the bar. And if it's egregious enough, I lose my license.
Yep.
And I'm not going to let one investor, I'm not going to do something goofy on a file and risk my license.
Yeah, it's incredibly important to go with your intuition and trust your gut. I tell people to do this all the time, especially when it's on a deal. Like if they're going back and forth, a lot of investors try to make a deal. And if you're trying to make a deal, usually it's not a deal. So guys, go with your gut. Now it's incredibly valuable to have someone like Shawn on your team. So guys, make sure you go out and find someone like him in your market. Now let's talk about your podcast here, your Crushing Debt podcast. I know why you would set something up like this, but let's go ahead and talk about behind the scenes why you went ahead and started this and kind of type of value. And because you're coming up on a big day, right? 100 podcasts. I'm sure you've had a lot of good guests on there. And let's kind of talk about that real quick. And then also you're actually going to be speaking at PodFest, which is one of the biggest podcasting events in the country every year. And that's coming up as well here. So let's go in and talk about Crushing Debt here real quick.
So the podcast is interesting. I'm one of the only attorneys I know in this area that has his own podcast. In fact, I don't know of any other attorneys in this area. I know other attorneys that have podcasts, but none in this area. And it was, behind the curtains, ignore the man behind the curtain. I was getting a lot of feedback from the people that were hosting and managing and tracking my website. And they all kept saying, Shawn, you need more content, you need more content, you need more content. And with all the other stuff that I've been doing, I do a lot of speaking, but it was hard to put all that down to paper. And so what I would do is I would drive around. And as I would drive around, I would talk to myself about, I want to write an article about X topic, and I want to do this, and maybe the intro will be this, and then maybe I'll put a joke in here about that, and I would just talk it and talk it and talk it and talk it. Right around the same time, I met Chris and Katie, or I reconnected. I've known Chris for years, but I reconnected with Chris and Katie Kremitzos, who run PodFest here in, it's going to be in Orlando, the second weekend of February, I think February 8, 9, 10. And they were just getting into their podcasts. And so I sat down with them and I thought, instead of just talking it out loud so I commit it to memory and then putting it down on paper, why don't I just click record on my phone? And that's what I started doing. And so the podcast literally has become sort of the frequently asked questions page. It is not, there are two types of podcasters. There's the ones like you, like me, that have the podcast to support their business. And then there's other people that have podcasts on topics that they think are fun. They just want to explore that topic more. It's a hobby of theirs, whatever. My podcast is specifically designed to support the law firm. So the topics that I talk a lot about bankruptcy. I talk a lot about foreclosures and short sales and loan modifications. I talk a lot about investor-related topics and land trusts and LLCs. And I have guests on. I had like I said, today, as we're recording this, the guest from today is a credit repair person. I've had insurance agents on my show. I've had probate attorneys talk about investing in probates on my show, family law attorneys. I've had other bankruptcy attorneys, people that you would consider competitors of mine, have great content to share. So I've had them on the show talking about eliminating student loan debt, eliminating other types of debt. And so it's really just a way, number one, it's grown to be something that I've become fond of. I enjoy firing up the mic and talking. And my shows, I know we've been going for a while now. My shows are only about 10 to 15 minutes long. So I try to keep my shows nice and short. But it's become now just, I've started to become known for it. And so then the next question I get asked is, well, have you monetized it? And some really cool stuff has happened. So I was here in where I live in my neighborhood. I was out getting dinner with my family really early in the life of the show. And I have the law firm's website on when I wear a logo shirt for the law firm, right underneath the collar on the back, it's got the yesnerlaw.com website on it. And somebody behind me in line said, "You work at Yesner Law?" I said, "Yeah, I'm Shawn." And they went, "Oh, someone turned me onto your podcast. I love it." And that was fantastic. I have had a person call me, and every time someone calls me, "How did you hear about me?" And they say, "Well, someone turned me onto your podcast," and I love it. So I'm getting clients from the podcast. other doors are opening for me. Like you said, I'm speaking at PodFest here in February, not as a breakout, but as a keynote to the entire seminar, which is going to be about 1,000 people we're anticipating. So the podcast has opened up other doors. I've never been shy about the microphone. I've never had stage fright. I enjoy speaking to people, and the podcast has even helped. Even though I thought I was a really good, accomplished speaker when I started the podcast, it's made me an even better speaker. It's made me, in fact, I had a group call me to speak on the same Thursday that I'm going to be speaking at PodFest, and I had to turn them down. I'm now running into situations where I had two people both try to pay me for a speaking gig, same day, same time. I had to turn one of them down. So, I mean, it's always a good problem to have when you're turning down people that want to pay you money, because you got other people that want to pay you money.
I mean, it's a great thing these podcasts have been coming out and getting more popular over the years. You're able to help a lot of people. A lot of individuals don't have the money to get in and pay some high-level mentor for coaching or even home study courses. And if I could go back and start my education process in the business again, it was a little bit into my business that I stumbled across podcasting and podcasts and social media. And I put up a lot of money where really, if you want to, you can go out there across all the different podcasts like yours, where you're giving out really good information on topics that most people don't hear about regularly, or you come on ours where we're talking about, investing strategies, wholesaling, flipping, rentals. It's just an incredible, valuable resource, and it's going to open up lots of doors. And like you said, you can start to measure your success not by the dollars in your bank account, but by how many people call you and tell you that you changed their life, or they email you, or they send you the letters with tears on them. These are the things that make people like Shawn and myself do what we do. And also, guys, if you're down there or you want to start a podcast, head on down to PodFest. It's an incredible event. Chris is a very genuine guy. Like you said, there's 1,000 people there. I think he shook the hand of every single person at the event last time. Just very classy guy. Let's go ahead and let you give your. I know we've gone a little long here. I held him hostage, guys. He's used to 10 minutes, but we got him here today. So let's talk about how they can contact you if they're in Florida, and kind of how they can find your podcast website, or where they can find it online. I'm sure you're on all the platforms. So let's go ahead and give them that information. We'll put it below here so they can click on it as well.
Yeah, I appreciate that. The best way to get it is to go to my website, which is yesnerlaw.com. And Yesner, I tell people, has one S in it, YESNER law.com. And a little ways down the page are all the podcasts. And you just click on the button there. You can listen to it on the internet. If you are an iPhone user, I'm on the Apple podcast player. The iTunes is typically what people call it, although it's the Apple podcast player. I'm also on Stitcher. I'm also on Spotify, iHeart, all the big, the way that podcasting works, you have your one host website, and that host website blasts it out everywhere else. So pretty much every major podcast player, I'm going to be there. And if you want to search, you just search Crushing Debt, and it should come up, the Crushing Debt podcast. Those are probably the two easiest ways. The law firm has a contact us page on it. So if you go to the yesnerlaw.com and you want to get a hold of me, or my email address is Shawn, which is SHAWN at yesnerlaw.com. And I would give my phone, but I'm typically faster to respond to emails than phone anyway. So that'll probably be the easiest way.
All right, guys, go support his show. Make sure you go to iTunes and leave a 5-star review and leave comments. This helps get out there. And if you like what you're hearing, share it around on your social media. Help him get his podcast out there. Shawn, grateful to have you on here today. And anybody I could come across, I think I can send you. I'm going to do so. And guys, if you're in Florida, reach out to them. You need someone like Shawn on your team. We'll see you on the next episode, guys.